Consumer Protection Act, that is 1986, is a legal status whose purpose is to provide for better protection of the interest of the consumers. It came into force on December 24, 12, 1986. Okay, and it was amended in 2002. Okay, salient features, aims and objectives. Aims and objectives to protect the interest of the consumers of different commodities. Example: TV, car, services, etc. Banking, airline, travel. It was seen that they paid but did not get a quality goods and or services. Quality and services. Before this act, there was no forum where the harassed consumer could appeal. The medical services, when the act was passed in 1986, medical services were not included in the act. Okay, medical services are not included in the act. This medical services not included in the act 1986. Medical services not included, that it was only after Supreme Court VP Shanda's decision that medical services were included in the act. Some salient feature definitions. Consumer is a any person who buys any goods or avails of any services by paying money. Section 21D. Service is any person who buys any goods or services includes under the act banking, financing, insurance, transport, processing, supply or electrical or other energy, board or lodging or both, housing, construction, entertainment, amusement, purveying of news or other information. Section 21. The services include excluded, that is services provided free of charge. Rationally, one cannot find a fault with the free service. Second is services provided under a contract of personal services. Rationally, the person providing services is under constant instruction and supervision from master. Okay, so master cannot find a fault with his servant services. Section 21. Okay, consumer dispute redressal agencies. There are 3 agencies, that is district forum, Section 9A, State Commission, Section 9B, National Commission, that is Section 9C, Constitution and Jurisdiction, that is district forum consists of a president serving a retired district judge appointed by the state government on the recommendation of a selection committee. Other members one shall be a woman. They should be more than 35 years, should possess a bachelor's degree from a recognized universities, should be person ability, integrity, standing, have adequate problems relating to economics, law, commerce, accountancy, industry, public affairs or administration. Every member hold this office for a term up to 5 years. Up to 5 years or up to the age of the 65. whichever is earlier. So section 10 jurisdiction, that is up to claims of 20 lakh. Section 11 powers for summoning, enforcing the attendance of any defendant or witness, examining the witness on oath and production of any document, etc. as evidences. The district forum still have the same power as vested in civil court under Code of Civil Procedure 908, section 13 for state commission consists of a president, the retired or serving judge of a high court appointed by the state government in consultation with the Chief Justice of the High Court and on recommendation of a selection committee. Two or more other members, which one shall be a woman. Other qualification same as those for members of a district forum. Every member hold office for a term of 5 years to the age of 67 years, whichever is earlier. Section 16 jurisdiction between claims of 20 lakh to 1 crore. Section 17 appeals against the orders of the district forum national commission. It consists of a president, serving or retired judge of the Supreme Court appointed by the central government in consultation with the Chief Justice of the India on recommendation of a selection committee. 2 or 4 or members of which shall be one will be a woman. Section 20 jurisdiction claims above 1 crore. Appeals against the orders of any state commission, multiple benches of National Commission and the State Commission to function for a speedy disposal of cases. Okay, next is manner of making complaints. A complaint in relation to any good sold or delivered or any service may be filed with a district forum by the consumer. If consumer dies, is legal heir or representative any here or any recognized consumer association, one or more consumers were one or more consumers having the same interest with the permission of a district forum, central or the state government, every complaint must be accompanied by a fees prescribed by the state government. Section 12 on receipt of the complaint, complainant, district forum may allow the complaint to proceed with or rejected after giving an opportunity to the complaint of being heard. Admissibility of the complaint shall be ordinarily decided within 21 days from the date on which the complaint was received. Section 12.3 frivolous or vexatious complaints are dismissed after recording the reason in writing. The complaint may be asked to pay of cost of up to 10,000 rupees to the opposite party. Section 26 procedure speedy trials. Every complaint is heard as early as possible, must preferably be decided within 3 months. No adjournment or ordinarily granted by district forum unless sufficient cause is shown and reason for a grant of adjournment have been recorded in writing by the forum. Section 13A. The complaint refers to any services. The forum shall refer a copy of such complaints to the opposite party, directing him to give his version of the case within a period of 30 days. An extension of 15 days may be granted. Section of 15 days may be granted according to section 13(2)(a). Okay. Notices may be served by a fax. Section 28(2). It is not necessary for a parties to be represented by lawyers. Every proceeding before a district forum shall be deemed to be a judicial proceeding with the meaning of section 193 and 228 of IPC. The district forum shall be deemed to a civil court. Appeal against the orders of district forum must be made to the state commission within 30 days from the date of order. If there was a sufficient cause for appeal later than 30 days, state commission will entertain it. Fees appellant must deposit 50% of amount ordered by district forum or 25,000, whichever is less. Section 15. Next is appeal against orders of state commission. Must be made to the national commission within 30 days from the date of order. If there was a sufficient cause for appeal later than 30 days, national commission can entertain it. Fees appellant must deposit 50% amount ordered by the state government or 35,000, whichever is lesser. Section 90. Appeal against orders of the National Commission. National Commission is empowered to review his orders to avoid rush to the Supreme. However, even if review does not give relief to a party, the appeal must be made to the Supreme Court within 30 days from the date of order. If there was sufficient cause for appeal later than 30 days, Supreme Court can entertain it. Fees appellant must deposit 50% of the amount ordered by the state government or 50,000, whichever is lesser. Section 23. Ensuring payment of a compensation. To ensure payment of a compensation, the consumer courts, district forum, state forum, national commission can attach the property of the opposite party and dispose it and recover amount due to the complainant. District collector would help the court to recover this amount. Finality of orders. If no appeal has been preferred against order of a district forum, state commission or a national commission, such order shall be final. Section 24. So finality of section 24. Limitation period. The district forum, state commission or national commission normally will not admit a complaint unless it is filled within 2 years from the date on which a negligence was committed. But under special circumstances, complaints after 2 years may be entertained if the forum or commission is satisfied that there is sufficient reason for doing so. It must be recorded in writing. The reasons for entertaining such a late complaint is section 24A. Who is covered under COPRA, Consumer Protection Act? All doctors and hospitals have charged for their service. All doctors and hospitals, including government hospital, health centers, dispensaries, who perform partial charitable services, who charge from a few patients only. Rich or and other poor are not charged. All rich and poor can benefit under COPRA. Who is immune from COPRA? That is all doctors and hospital, including government hospital, which are doing a completely charitable services, not charging anyone. Neither rich or poor can charge it. Hospital charging a token amount for registration purpose. It is not a payment for the purposes of COPRA. Criticism. As there is no scope for testimony by medical expert, the forum and commission come to their own conclusion, which may be wrong. Many frivolous cases are likely to be filed against doctors. Next is Indian Medical Association versus VP Shanda, 1995. Citation: Indian Medical Association, VP Shanda. 1995. Fact is VP Shanda husband died as a result of medical negligence of Cosmopolitan Hospital, Kerala. VP Shanda, VP Shanda, VP Shanda claimed compensation under CPA 1986. The hospital claimed that doctors were not covered under CPA as they were exempted under Section 2(1). 1986 claim was however aborted by the State Commission. Decision was upheld by National Commission. Cosmopolitan Hospital Cosmo appealed, but the Indian Medical Association rejected as a third party, fearing an adverse reaction against doctors' issues. Whether and in what circumstances a medical practitioner can be regarded as rendering service under Section 2(1). Section 2(1) of the CPA regarded as service under Section 2(1) of the Act. Existing law at that time, doctors were not included in CPA since the inclusory provisions of Section 2(1), which defines service, especially failed to mention their profession. While mentioning other professions such as banking, financing, insurance, Section 2(1) also have two exclusory provisions. The services did not include the services rendered or free of charge, service rendered under a contract of personal services. Doctors were excluded because they were supposed to render a service under a contract of personal service. Judges, lawyer of VP Shanda, trial and judgment, a doctor would be included under CPA 1987 henceforth. The reasoning. The court specifically differentiated meanings of contract of service and contract for service and contract of service. Contract for service and contract of service. Contract for service is a contract where one party undertakes to render service such as professional or technical service, another in which a service provided is not subject to detailed direction and control. The provider exercise professional or technical skill, use him doctor is a profession and is not subject to a detailed directional control of the patient. This is in sharp contrast to a domestic servant who is unskilled and is under detailed directional control of master. The doctor is under a contract for service, not under a contract of service. A domestic servant is under a contract of service. Significance and outcome. Doctors were henceforth subject to the provision of CPA. Major criticism. Doctors are already under the supervisory control of MCA. They cannot behave like ordinary traders. Advertisement, putting a large hoardings, employment stores. Such act would attract the penal action by a Medical Council of India. Still, the CPA treats them as traders, thus they would bear deals from both. Thank you.